Okay, welcome back, everyone. We are now into the second session on the zoning track for today. The presentation is the ZBA in New Hampshire, and our presenter is Jason Dennis, a partner at Hastings Law Office, which is located about a mile from the New Hampshire border in Freiburg, Maine. Jason, who resides in New Hampshire, has been a member of the New Hampshire Bar since 2010 and is a graduate of the Bar Association's Leadership Academy class of 2016-17. Jason has an active municipal and land use practice. He serves as legal counsel to several New Hampshire municipalities, but he also occasionally represents property owners before municipal boards in towns that he does not represent. Jason earned his Bachelor of Science in Psychology at Roanoke College in 2003 and earned his JD from Indiana University in 2008. So welcome, Jason. And what you can do now is, Jason, you can click on the button at the top of the banner on the left to take control of the slideshow. Great.
Okay. Thank you, Ken. And thank you, Cordell, for your presentation as well. Whereas Cordell, everyone spoke to you all about the process, the procedure of ZBA meetings and hearings. My job today is to speak to you a little bit about more the nitty-gritty of the decision-making process based on the types of decisions that ZBAs are authorized to make and the law that applies in getting to those decisions. One of the things that Cordell said at the beginning of his presentation was that ZBAs came into existence as a sort of check against maybe overreaching or potentially unconstitutional zoning ordinances relative to what they have to say about what people can do with their own property. What I would say is that people are still very concerned with what municipalities say they can and cannot do with their property. And for that reason, there's a lot of case law on these topics. And so there's a lot of slides for me to get through, and I will try to do that as quickly as possible. I'll take some questions in the chat, perhaps, depending on timing, but I also will, sorry, I'm just scrolling to get up to the slides for my presentation. It went back to the beginning, it looks like. So here we are. So what can the ZBA do? What decisions is it statutorily authorized to make? What types of cases does it hear? Pursuant to RSA 674-33, zoning boards have the power to hear and decide appeals of administrative decisions. They can grant variances and they can grant special exceptions if special exceptions are provided for in the applicable zoning ordinance. And then pursuant to 674-33A, zoning boards can grant equitable waivers of dimensional criteria. And so starting with appeals of administrative decision, those are appeals if there is an alleged error with regards to a determination made in the enforcement of a zoning ordinance, a permit granted, not granted, things of that nature. And the appeals, and this was a slight change effective September of 2024, may be taken by the applicant in a butter is defined by RSA 672-3, or as Cordell was talking about earlier, offices within the town. A butter has, as you can see on the slide, a very lengthy definition, and I am not going to leave this slide probably long enough for all to read it, and I am certainly not going to read it, but it is a relatively clear definition there, and that definition is what applies in the context of who can make the appeals from the abutter side of things. The appeals are from decisions made by administrative officers, and that has a shorter definition, which is any official or board in the municipality responsible for issuing permits, certificates, etc. And as you see there, it can include building inspector, board of selectmen, or other official board with such responsibility. And in a way, this actually applies to planning boards too, as we will see as we get through some of the slides. Zoning board can hear aspects of a planning board decision that relates to zoning. And I'll talk about that a little bit more as we get there. The appeals of an administrative decision, it must involve the construction, interpretation, or application of the terms of an ordinance, not a ministerial or discretionary decision such as for enforcement. So for example, if a town were to go to court, Superior Court, to take enforcement action, that wouldn't be appealed to the ZBA, but an enforcement letter or notice of violation could be appealed to the ZBA. And you'll see there, I've cited a case here, Sutton v. Town of Guilford, that says challenges to building permits must first be made to the ZBA. Excuse me. So one case that deals with this is the New Hampshire Alpha of SAE Trust v. Town of Hanover, and this was a fraternity house case in which the fraternity was recognized as an official fraternity on campus. And the case actually, though, started prior to 2019, because this was the second of 2 appeals, and it is actually still ongoing, is my understanding from speaking with some of the counsel, or one of the counsel that's involved in this case. This case stands for the proposition that the Superior Court in the first instance, and then Supreme Court coming after that in reviewing the decisions, the review in zoning cases in general is limited. And in part what that means is that, as it's stated here in the slide, the factual findings that are made by a zoning board are deemed to be prima facie lawful and reasonable. So they get the benefit of the doubt from the start. Of course, anybody that's challenging this can overcome that sort of prima facie benefit of the doubt. But ZBAs start off with the court looking at their decisions as lawful and reasonable. The decisions will be set aside for errors of law, or if the decision is deemed to be by the court as an unlawful or unreasonable decision. That said, when interpreting a zoning ordinance and legally arriving at a decision on appeal, the court reviews the statute de novo. This, for example, is why the New Hampshire Supreme Court was able to reach different outcomes in the 2 bigger short-term rental cases, the case out of Portsmouth and the case out of Conway, because the Supreme Court was analyzing the language of each ordinance de novo, meaning new on its own. If the Supreme Court was just applying generic principles of law, it would be harder to justify how they could, in one instance, say short-term rentals could be regulated, in another that they could not be. The reason that can be so is because, again, the court will review each ordinance, review the language of each ordinance, including definitions, in a de novo, meaning, again, new basis. As for one concept that Cordell had mentioned, which was constitutionality of zoning ordinances, one interesting point that comes out of this New Hampshire Alpha of SAE Trust case out of Hanover is there was this aspect of the decision in which the fraternity house needed to be operating, quote, in conjunction with the college. And one of the challenges was that, well, by saying it has to function in conjunction with the college, that provided the college, and stripped this away from the zoning ordinance, the ability to make this decision. So if the college derecognized the fraternity, then the college is in charge of the zoning ordinance and not the town, not the legislative body and enactment and the enforcement bodies. But what the court said there is that if a local zoning ordinance conferred upon a private landowner or an institution the authority to grant a special exception or to impact the application of the zoning ordinance without the town or the zoning board being able to make an independent decision, that would likely be an unconstitutional delegation problem. So in this case, the court decided that there were other elements that came into play in deciding in conjunction with the college, other than whether the college specifically recognized this fraternity as a institution on campus. Some other points, quick hitter points from this case with regards to how the ZBA operates in these types of cases. And I'll start with the first bullet point here, which goes to the point I was making earlier. This case is still ongoing. As of right now, relatively recently, the Superior Court on the continuing challenge and appeal of this case has decided that the fraternity is not an institution within the college in and of itself that is likely to continue to be appealed. But some of those quick hitter points, because all of these were raised by the fraternity in an attempt to overturn the decision. But the Supreme Court in this case has reaffirmed that a lack of prior enforcement does not necessarily prohibit current enforcement, meaning if a town did not take enforcement action for something perhaps similar, that does not automatically bar enforcement in a current situation. Of course, if a property owner is able to successfully show a selective enforcement, that could change the outcome. But mere lax enforcement, or for example, complaint-based enforcement, and number of towns engage in complaint-based enforcement, they simply don't have the staff or the personnel to be continually investigating certain types of zoning violations. And so they will take enforcement action based on complaints. And so if there are 10 violations that nobody's complained of, but you then get a violation for one and take enforcement action on that, this case stands for the proposition that enforcing against the one and not the other 10 in and of itself will not prohibit the enforcement. Similar to some of the points that Cordell made, the ZBA is in fact free to accept and reject evidence and draw reasonable inferences from facts provided. This is because, as Cordell said, the ZBA is acting in a quasi-judicial manner. In this fraternity case, one of the things that had happened, if I'm recalling correctly from maybe the first appeal, but the college hadn't participated. And somebody on the ZBA said, hey, we better give them a copy of this decision. And then when the college got it, they came and said, yeah, we want a rehearing on this, and there was some more procedure. As you could perhaps imagine, the fraternity wasn't too happy with that process being afforded to the school after they thought were going to be successful. The court said that the ZBA has broad authority to grant a rehearing upon a motion, and that the ZBA can reverse itself if the interest of justice so require, and that particular ZBA member that specifically requested Dartmouth be notified of the decision was not determined to be biased, so it would not have had to recuse themselves, which is a topic that Cordell had talked about. Of course, this follows that these decisions are public decisions, and so anybody could have had access to it. So the fact that a ZBA member sort of made this specific decision to specifically ensure that Dartmouth got this was not determined that they were biased and should have recused themselves. So I mentioned the appeal of administrative decision regarding planning board decisions. And you could probably get different opinions on this from the fact that, well, planning board decisions really don't have zoning components at all, to every planning board decision inherently has some measure of a zoning application decision, because if you're approving a site plan, you're approving the fact that use is a permissive use. And so under RSA 676(5) Roman numeral 3, if in the exercise of the planning board's duties, review of a subdivision or site plan review, for example, there is a decision that is a more typical zoning decision, construction interpretation of that document, that decision may be appealed to the Board of Adjustment. If it is a pure planning decision, such as amount of green space, it doesn't have any real zoning component to it or something like that, that would go straight to the Superior Court. And also, as the second bullet there points out, if you have a innovative land use control that is adopted pursuant to 674-21, and that delegates administration to the planning board, those appeals would also go directly to the Superior Court, not the ZBA. Now, when is a planning board decision ripe to be appealed to the ZBA? And that is, it sounds almost silly, but the court views it as when such a decision is actually made. What does that mean? In the Atwater v. Town of Plainfield case, the court made clear to point out that the planning board does not need to have completed its review, consideration, decision of an entire site plan for the zoning issue to be ripe for appeal to the ZBA. And the quote here, and I will read part of it, is that it makes little sense to require that the planning board's approval of a site plan be final before a party can appeal to the ZBA on a zoning issue, including something as fundamental as whether the proposed use is allowed by the zoning ordinance. Now, that said, in the Accurate Transportation Inc. v. Town of Derry case, a mere vote to accept a site plan as complete was deemed in that case not enough to trigger obligation to bring an appeal to the ZBA. And so planning boards go through a checklist to determine whether an application is even complete to go forward with the meeting and or hearing on a site plan or subdivision. And the decision to accept a site plan as complete really is not a zoning decision. It just means that you've given us the information we need, whether it be elevations or surveys, etc., so that we can, as a planning board, make the decision. If there then is a conditional approval of some variety that approves of a use that may be in question from the zoning ordinance's perspective, that's the type of a decision that could then be appealed to the ZBA. A few more, I guess I'll call them quick hitters again, points on appeals of administrative decisions that come out of a number of cases from the New Hampshire Supreme Court is that in the Batchelder v. Plymouth case, in that case, if the removal of fill was decided to be incidental to lawful construction, and so that dealt with the ZBO, a zoning ordinance interpretation. So that was an appeal of administrative decision. I've talked about the case, but two of the terms that were important in getting to some of the decisions coming out of that case were whether the fraternity was operating, quote unquote, in conjunction with another institution. And then they also analyzed the concept of a non-conforming use. Non-conforming use is not a topic that I will talk much about in the context of this presentation. It's its own sort of separate subtopic. There's a lot of case law on what is and is not a non-conforming use. Grandfathered use is a term often used for a pre-existing non-conforming use. I will talk a little bit about it, but not extensively. In the Working Stiff Partners LLC case, that was really the first big short-term rental case that went up to the New Hampshire Supreme Court. What happened in that case was that the term dwelling unit was interpreted to exclude certain other terms. And the New Hampshire Supreme Court used a Latin concept, e justem generis, which basically just means that if they read some terms in the zoning ordinance and those terms were similar enough to other types of terms, that could lead to the conclusion. In this case, what that was that the Supreme Court determined that in the Portsmouth ordinance, transient occupancies that were similar enough to hotels, motels, rooming houses, and boarding houses were not permitted. So that supported the decision to prohibit short-term rentals. Administrative decisions sometimes arise in unique circumstances. Two cases I've put here on the last bullet point are the town of Lincoln versus Chenard and the city of Laconia versus, and I'm probably going to butcher this name because I was not involved in this case in any way, but Jalander. These were both junkyard cases. It's an interesting distinction that was made in these two cases through the appeal process. In the town of Lincoln case, junkyard was not defined in the town of Lincoln's zoning ordinance separately. It didn't have its own definition. There was cross-reference to the state junkyard statutes. And so in the end, what happened in the town of Lincoln case was that while the Superior Court and ultimately on appeal, the New Hampshire Supreme Court upheld the enforcement decision that was made by the town that the nuisance that was created by this junkyard had to be abated, had to be cleaned up. Neither the Superior Court nor the Supreme Court ordered an award of attorney's fees, which is available under enforcement statutes in the state of New Hampshire for zoning enforcement. The difference in the Laconia case was that in that case, the property that was being challenged, the use of the property that was being challenged as a junkyard, met what the city had for a definition of junkyard. And so in that case, ultimately when the town prevailed against the person's use, they were entitled to an award of attorney's fees. And so these two cases, I think, very strongly support that on appeal, once it gets beyond the ZBA, if it does, these types of decisions are made based on a very close analysis of the specific ordinance in question. I would add here that obviously no zoning ordinance can define every possible term. And so to be sure, there are instances where ZBAs can and should rely on the common usage of definitions. The Superior Court, Supreme Court may not uphold those definitions as determined by a ZBA, of course, but without a definition built into the zoning ordinance, that's really all you have to work from. As far as the timeliness of appeals, Cordell talked a little bit about this, but I would say that just in the interest of time, just pay attention to the timeframes. And if there are any further questions on timeliness, those I assume would be able to be answered during the question and answer at the end with Stephen and Cordell. That said, effective September 13th of 2025, RSA 676.5 Roman 1 requires appeals to the ZBA to be taken within 30 days, no longer the reasonable time standard. There were certain towns out there that had a 14 or 15-day appeal period over the last few years, and ongoing the legislature, it appears, is trying to more or less streamline the appeal process, at least the time component of the appeal process for these types of things, to get it more or less to the 30-day period, which is often the time frame through the court system. So more or less streamlining the ZBA appellate process with the Superior Court appellate process. As I alluded to previously, under RSA 676:5 Roman 3, the appeal period starts to run from a conditional approval, and that's the Saunders v. Town of Kingston case, which I've noted there. One important thing is appeal period deadlines. If they are missed, they are deemed to be jurisdictional, meaning that for the Superior Court and then obviously no appeal further after that, of course, if there isn't one made to the Superior Court in the first instance. By them being jurisdictional, what that means is it takes the ability of the Superior Court to hear the matter away. So they really cannot be waived in that instance. The exemption under RSA 674-39 for relying on zoning relief. It used to be 4 years, it's now 7. One important piece to note here in this slide is that this does not apply to amendments to previously approved site plans that substantially change the plan. Meaning, if a ZBA, in looking at an appeal, thinks that there's an exemption here, if there was some change back at the planning board level that substantially changed the plan, then this exemption does not apply, meaning the ZBA may have some different level of discretion or jurisdiction if an appeal comes the ZBA's way. And this comes into play in the Harborside v. City of Portsmouth case. In this case, there had been a site plan for a hotel, a restaurant, and a retail space. However, the developer came back and wanted to add a conference center to their site plan. There had not previously been a conference center as a part of the approved site plan. So the ZBA in that case upheld the planning board's approval, and they were relying on the exemption. However, the exemption did not apply because the court determined that including a conference center was, quote, qualitatively different from retail space. And so since the exemption did not apply and new parking requirements had been put into place after the original site plan had been approved, the amendment was deemed not to comply with the new parking requirements. The amendment was deemed not to have an exemption. And so when the ZBA upheld the planning board's approval, that was deemed to be legally in error in that appeal. One interesting component in an administrative appeal, or at the crossroads of an administrative appeal and a request for a variance, is that if a request for a variance comes in, the Bartlett v. City of Manchester case stands for the proposition that, well, if you're determining if a variance is needed, necessarily you're saying that it's a non-permitted use and therefore you need the variance, and then go through the variance criteria, which we'll talk about. But this case stands for the proposition that the ZBA had the authority to essentially make a determination on an unappealed administrative official's decision. Because in the context of the variance, they were able to say you don't need one because this is a permitted use. As stated in the case, contained in every variance application is the threshold question, whether the applicant's proposed use of a property requires a variance. And it's important. This is important because an applicant is not deemed to have waived a claim that a proposed use is permitted as an accessory use just because they apply for a variance. Back to that fraternity case, if a zoning officer issues a violation notice that is an interpretation of the zoning ordinance, the case makes clear that the ZBA can hear that matter. What happens when there is an administrative decision? 676:6 tells us that an appeal to the ZBA has an effect of maintaining the status quo. and it suspends any appealed permit or certificate, which means no construction, alteration, change of use in the meantime. An appeal of an order or enforcement, it stays enforcement, but I'll quote here, unless the officer from whom the appeal is taken certifies to the Board of Adjustment that by reason of facts stated in that certification, a stay would, in that officer's opinion, quote, cause imminent peril to life, health, safety, property, or the environment. So that sets up a little bit of a component of the zoning officer having to convince the ZBA that this imminent peril exists in order to engage in any enforcement during the pendency of an appeal. In contrast, pursuant to RSA 677-9, the filing of an appeal with the court shall not stay enforcement proceedings and shall not have an effect on suspending the decision of the Zoning Board of Adjustment. I have recently dealt with this in the context of a cell tower, and there's an interesting other legal component to this too. It's actually pending decision from the New Hampshire Supreme Court. But in this cell tower case, both the planning board and the ZBA had weighed in to grant the approvals and variances, special exceptions, except everything necessary to get the cell tower to be permitted. And then sometime later, the building permit had come in. One of the abutters who had challenged through the Superior and up to the Supreme Court process from the prior appeals of the planning board and zoning board decisions appealed the issuance of the building permit. And so that went to the Superior Court and is now pending at the Supreme Court. That appellant sought a stay of the building permit, and that was denied, meaning that cell tower has been able to commence construction. Now, of course, the caveat disclaimer there, perhaps more important for developers and property owners than the ZBA or the town, is that just because there is no stay, meaning construction can commence, that does not mean necessarily that whatever is built while the appeal is pending gets to stay if the Supreme Court reverses the approval. The other little note about this from a legal perspective is that in that case, what I argued to the land use docket court was res judicata, collateral estoppel, an argument basically to the court that this issue has been heard before. What I argued was that because the building permit in that case only was a quasi-ministerial act of allowing the building to commence for the project that had already substantively been approved by the planning board and the zoning board, and appealed to the Supreme Court and the Superior Court and the Supreme Court and been upheld, was a decision that had already been made. And Cordell had talked about one bite of an apple with regard to applications, but when it comes to legal challenges, there's really supposed to be one bite of the apple as well. And so even though we were at a different phase of the project, going from getting the permissions from planning board, zoning board, to getting the building permit issued by that officer, it was the same substance, meaning it was the same tower being constructed. The legal decisions had already been made, appealed, argued, and affirmed. And so the trial court simply dismissed that appeal, saying you don't get to ask this same question in substance again. I'm waiting to see what the New Hampshire Supreme Court says. But I thought that important to share in the context of administrative appeals. Now, while zoning boards don't always have full authority, so to speak, to decide constitutional issues, administrative appeals can include them. in challenging zoning ordinance provisions. And in fact, even if the zoning board doesn't have the legal authority to make the decision, an applicant is probably wise to include them from the very first instance, so they don't end up being deemed to have waived them when they get to the court. That may be the more appropriate body to make those types of constitutional decisions. So quickly on these, in the Concord case, there was a provision that signed ordinance disallowed electronic changeable copy that was found to be constitutional and not in violation of free speech, etc. In the Manchester case, there was a complete ban on federal halfway houses. That was not deemed to be constitutional. And one interesting thing that happened in that City of Manchester case is that the court granted a builder's remedy, which essentially was the Supreme Court saying to the City of Manchester, hey, in the event that you attempt to make any changes to your ordinance that continues to prohibit this from being done, we determine that it's reasonable and that he'll get to do this regardless of your changes. So a builder's remedy was granted in that case. That's not something that's done very often. I'm going to move on just in the interest of time, because the constitutional issues really generally end up being played out more in the Superior Court and Supreme Court level. But just know that if you're sitting on a ZBA, they may come to you. Same with municipal estoppel. Although that issue is often litigated more in the courts than at the ZBA level, it's certainly something for the ZBA to take into consideration as well. The elements of municipal estoppel are that a representation or a concealment of material facts was made by the municipality, somebody on behalf of the municipality, an agent officer with actual knowledge of those facts, and that the party to whom the representation was being made was unaware of what the true facts were, and that the representation was made with the intention of inducing that party to rely on it, and 4, that the other party reasonably relied upon the representation to the detriment. So if a property owner communicates with the town, is given certain information and relies on that information, there may be in the end a municipal estoppel issue, such that even if what that person has done is not permitted, that person can be deemed to be allowed to do it anyway because of this municipal estoppel issue. And there are obviously a few cases there that I'm going to leave for you to review on the slides at your leisure. And obviously for anything, if there's questions, they can be asked at the question and answer session. I think my email is available for questions too. As I said at the outset, these things are often litigated. And when you look at 2 cases, you may very reasonably be absolutely unable to determine how on earth one went one way and one went the other. That is both the beauty and the frustration of municipal attorneys dealing with the litigation of land use issues. And so always, if you have the ability to check with counsel on these things, as they start to get into some of these more complex legal issues, as Cordell said, not that any of us are looking for extra payday, but it's always good to check with counsel. As I said, in this bullet point here, just as reiterates that, is while the ZBA is not specifically conferred jurisdiction to give relief based on municipal estoppel, which I think I saw a question pop up. Estoppel just means that a town is barred from applying some aspect of provision or zoning ordinance because of the town's own conduct directed towards the property owner, that property owner acted upon reasonably to their detriment. So if a deck. Maybe they shouldn't have the deck where it is attached to their house for whatever variety of reasons. But they go to the town, and the town tells them absolutely they can have it and gives them all the reasons why. The person spends money to get the deck built, and then lo and behold, somebody complains, and they're told that they can't have it. There's at least a question. Who knows how these all may play out, but at least a question as to whether, regardless of what the ordinance might say about setbacks or anything else having to do with that deck, that nonetheless the person who built it gets to keep it because of this municipal estoppel doctrine. Interesting case, although it's older now, and this law was being tinkered with for a while because there were some folks in the legislature that had sort of an interest in trying to help farmers and folks with agricultural land to be able to continue to make use of their property when traditional farming is no longer viable for them on farmland. But in this case, Forster v. Town of Henniker, the decision was that weddings were not a valid accessory use under the statutory definition of agriculture or agritourism. Accessory use is a use that is occasioned by and subordinate to the principal use. And one component of this, which applies to really decisions for other accessory uses as well, is that it must be associated with a frequency that is substantial enough to rise above rarity. In this case, the petitioner had failed to prove that this was a common enough practice to be an accessory use. One case that's interesting as far as what the ZBA's authority here is, this case, the Willett case, just confirms that the ZBA has the ability to conduct a de novo review under RC 674-33 of a historic district commission. The historic district commission in this case denied a certificate for a supermarket, and the ZBA, the de novo again, is just they got to hear it as if it was their case for the first time. Meaning, as the bullet indicates here, they didn't have to give any level of deference to the rulings of the historic district commission. So that takes us to special exceptions, and I'm probably going to speed up here simply to get through the material, because variance is the big one that I have sort of saved for last. But special exceptions are meaningfully different from variances. Special exceptions are uses that are actually allowed in the ordinance. They're just allowed subject to a special exception, meaning if you meet the criteria for the special exception, the use is a permitted use, whereas a variance is you are seeking relief from the enforcement of the ordinance that says you cannot make this use or make this use in this way or within this setback, etc. If your zoning ordinance doesn't provide for special exception and provide conditions, then it's not really something that the ZBA can do on the fly. The zoning ordinance should provide the checklist for all the conditions for any use for which a special exception would be available. Important points on special exceptions is that you cannot waive any of the requirements. So if in order to get a special exception for I think Cordell used a restaurant use, so I will use that as well. For a restaurant in a zoning district in which a restaurant is not allowed just by right without doing anything else, you have to meet 4 criteria, whether that be hours of operation, number of seats, signage or no signage, or whatever it may be. If it's being brought to the ZBA as a special exception, all of the criteria need to be met. Now, that said, the applicant could seek a variance for the project as a whole, as opposed to going through the special exception route. They could seek a variance saying, well, we should be allowed to do this outside of the context of the special exception and just be allowed to do it as a use permitted by the variance or allowed by the variance. as is the case, often the applicant has the burden of presenting the evidence to sustain the finding on the requirements. Each of the requirements, whatever they may be in a particular ordinance for a particular use. Special exceptions, I think Cordell said this, they run with the land. However, there is at least some possibility that a special exception could be lost by abandonment if the zoning ordinance indicates as such. Special exceptions by statute shall be valid if exercised within 2 years from the date of final approval or as further extended. And then RSA 674-33 Roman 4 sub C. That statute, I won't read the whole thing, but it allows to terminate special exceptions authorized depending on when they were authorized and what the other conditions are. So just take a look at that if there's interest and question in that concept. Variances. This is the topic that may be one of the single most litigated topics in land use. And a variance is, as stated here, relief from the literal enforcement of the provision of a zoning ordinance. So the zoning ordinance says, for whatever reason, you cannot do this. An applicant can seek a variance. They must satisfy all criteria. There are 5. The first 4 are the variance will not be contrary to the public interest, the spirit of the ordinance is observed, substantial justice is done, and the values of surrounding properties are not diminished. 1 and 2 are essentially going to be treated legally the same by the courts. And I can tell you this because I tried to argue before the Housing Appeals Board that the spirit of the ordinance should be given some slight different analysis or treatment. I thought that if that was the case, I had an argument to help my municipality out. The Housing Appeals Board really wanted nothing to do with that argument. So 1 and 2 are really going to be treated the same, and I'll tell you more about them in a moment. 5 is the one that has been the biggest subject of litigation and change statutorily, and then cases, and the legislator reacted and vice versa. And so it's changed over time. But it may be changing slightly again, depending on how the legislature does things this session. This criteria is that the literal enforcement of the provisions of the ordinance would result in an unnecessary hardship, which is defined as owing to the conditions of the property, not anything to do with the property owners, the property itself, that make it different than other properties in the area. There's no fair and substantial relationship that exists between, why we've got this ordinance provision existing in the first place and the use that they want to make. The use, of course, does have to be a reasonable one. 5B is, from practical effect, actually very similar to A, but it said if the criteria in subparagraph A are not established, an unnecessary hardship will be deemed to exist if and only if, owing to special conditions of the property that distinguish it from other properties in the area, the property cannot be reasonably used in a strict conformance with the ordinance, and a variance is therefore necessary to enable a reasonable use of it. So you see the two common elements are there needs to be a reasonable use, and the issues need to arise out of the conditions of the property, not any particular property owner. So you have to examine the use as it exists on that property, regardless of who the applicant it may be. Now, I just do a quick call back to that Bartley v. Manchester case, which means if somebody is coming to seek a variance, that entails with it the question of whether a variance is even needed. It may very well be that somebody thinks they need a variance, but the ZBA or somebody else ultimately makes a determination that, no, this is a permitted use. You don't even need the variance in the first place. A few cases that I'm going to go through to talk about the application of these criteria. Peralt v. the Town of New Hampton. In this case, there was an individual that wanted to put a permanent shed within a side setback. There were, on this one shed, there were 4 public hearings, 2 site visits. The abutter supported it. And the fire chief had actually okayed the request in this case, as well as is not having, any too big of a problem with regards to, the fire chief's opinion of life safety types things. The ZBA okayed it, and it was upheld by the Superior Court and the Supreme Court. So criteria 1 and 2, the Peralt case is one of the cases that confirms that really these are the same. And that criteria is that mere conflict with the ordinance is not enough. There has to be, quote here, the variance must unduly and in a marked degree conflict with the ordinance such that it violates the ordinance's basic zoning objectives. And the court looks at a couple things, whether the granting the variance would alter the essential character of the locality or threaten public health, safety, or welfare. If either of those two things are decided, that is certainly a basis to deny the variance if it alters the essential character of the locality or threatens the public in that way. The Supreme Court in this case, and so I think it's fair for zoning boards to continue to take this at least somewhat into consideration. The Supreme Court assumed without deciding that cumulative impact is a proper consideration in the variance context. Interestingly, importantly, the Supreme Court also found in this case that a municipality exercising zoning power solely to advance aesthetic values, there was no error with that being done at the sort of town and the ZBA and Superior Court level, that if there was a provision in place and that it really is just for aesthetic purposes, that in and of itself will not be overturned by the court. In this Peralt case, the applicant argued a number of things which are important because they were rejected by the court. The applicant argued that other outbuildings were within setbacks, and so basically they're being treated differently, which could rise to the level of a constitutional claim, but also a fairness claim and a reasonable use claim because other people are doing it. And the ZBA had made a number of findings about those other outbuildings, which include the ones listed here, that some of those folks got variances that were granted when the old variance criteria applied, so maybe a little bit easier, so they were able to get it. The criteria is new now, and so, sorry, we have to apply the current criteria to you. We cannot apply the same criteria. The law has just changed. Some of the outbuildings predated setbacks, and as long as they were a lawful pre-existing use, they were okay to be there. So they weren't actually a violation for which any enforcement could lawfully take place because they were a appropriate grandfathered use. Some, there was just a factual determination made that, hey, these are not actually within the setback. And if that type of factual determination is made by the zoning board, that's going to be, again, as stated at the outset, given deference. However, that factual determination is made, whether it be a site visit, measurement, pictures, etc. And some were simply not known to the town, meaning this concept, again, of complaint-based enforcement. If these existed and nobody brought it to the town's attention, the town wasn't being punished by the court by not having enforced something they didn't know about before and did not have to give a new applicant the same thing. The Harborside Associates case is a case in which a hotel wanted to have 4 total signs that departed from the literal language of the zoning ordinance. 2 were parapet signs that were simply not permitted at all, and then 2 were marquee signs that were in excess of the maximum sign area allowed by the ordinance. In this case, importantly, the ZBA made a number of, and this goes to Cordell's point, and this actually can help things be much more efficient in the town level. If you make these findings, it can avoid having to get remanded back to the ZBA to have another hearing on something. But anyway, so the findings made by the ZBA in this case very much helped the town and the ZBA in efficiently going through this case. The Superior Court in the case affirmed the decision on the marquee sign, but overturned the parapet sign decision. Whereas in the end, the Supreme Court upheld all of the ZBA's decisions on the 2 parapet signs and the 2 marquee signs. And they used, which was at the time, the new statutory variance criteria. Again, criteria 1 and 2 deemed to be the same. One interesting point here is that the Superior Court, in analyzing the criteria, had said, well, granting the variance won't serve the public interest, and since the variance doesn't benefit the public, it's no good. The court ruled that the Supreme Court ruled that was legal error because the criteria is not whether the granting the variance will benefit the public, it's whether granting it would harm the public. So if it's neutral, I guess one way to talk about this is if it's neutral, and there's no benefit or no harm, then you're likely in a situation where these criteria are satisfied. The applicant does not have to prove that getting the variance will benefit the public at large. And so as to those findings of facts, the Supreme Court was able to, though the Superior Court had reversed this decision, the Supreme Court was able to determine that based on the record that was provided to them and the factual findings that were made, instead of just reversing this and remanding it back to the ZBA to make further decisions, they could uphold the ZBA's decision based on the record. And so it saved having to go back to the ZBA. So make those factual findings. As to the substantial justice criteria, it really boils down to the quoted language here. The only guiding rule on this factor is that any loss to the individual that is not outweighed by a gain to the general public is an injustice. The Superior Court was deemed to have made a legal error when they focused on what the benefit to the public would be by granting the variance, similar to the error they made with the other 2 criteria. So the Superior Court was saying, what benefit does the public get if we grant the variance? And the Supreme Court said, no, that's wrong. The ZBA actually got this right. They focused on whether the public would benefit from denying the variance. And that might sound very semantic or a very subtle difference. But again, it's the idea of granting the variance does not have to benefit the public. And what you're weighing here is if we deny this variance. And so, for example, if the signs in that case, if the ZBA had decided if we deny this variance, that will benefit the public because there will be less visual clutter and less maybe visual distraction, which creates a hazard on the roadways by denying the variance. So that's the benefit to the public. And it doesn't really harm the applicant because they can have a smaller sign and they can do these things that give them all the information they need to make the public aware of for their hotel. That likely would have been able to be upheld. They decided the other way and that ultimately was upheld too. Interestingly, in this case, which perhaps if you'd asked some municipal attorneys at the time, they might not have all agreed that it would be able to go this way because of this sort of focus on we're dealing with the special conditions of the land. In this case, because the variance was to install a sign on the building, the Supreme Court decided that the ZBA and the Superior Court in first instance did not create a legal error, did not make a legal error by focusing upon the building size. So the building on the land as opposed to the land itself to determine whether the property had special conditions. In this case, the property owner did not have to demonstrate that the proposed signs were necessary to its operation, only that they were reasonable, because again, of course, the variance criteria is it's a reasonable use. And importantly, the Supreme Court rejected this idea that because there could have been smaller signs. Now, again, there was no finding of visual clutter or anything either. So that would have potentially been able to change the outcome. But the Supreme Court said that because the same result could have been achieved by installing smaller signs or conforming signs, that's not the test. It's not, that's the old test for an area variance. It's reasonable use. And so the last bullet point there makes that point pretty clear. It's no longer that the benefit they seek cannot be achieved by reasonably feasible means other than an area variance. ZBA does resolve conflicts in evidence, and they assess the credibility of offers of proof. Your ZBA members are making that decision just like the way a judge does in a bench trial. The judge determines credibility. The ZBA doesn't leave its knowledge and experience at the door. I'm not quoting that exactly, but that's one of my favorite quotes from a land use case, is that board members don't come in and have to just sort of wipe their knowledge base clean. They can rely on their own knowledge and experience. And as Cordell said, you don't have to accept opinions of experts. However, if that's all you've got and nothing else to counter it, you're probably going to be setting up a decision that's going to be more easily attacked if you just reject something out of hand. I'm looking at a clock here just to make sure I've got time to make through the rest of the slides here. In the Malachi Glenn Associates case, there was discussion in the meeting. This goes to making the right motions, having the right discussion, making the right votes, and getting things on the record. There was discussion in this ZBA hearing about concerns with wetlands, etc. But there was never an actual decision made as to that this was a definite problem. And so one of the things the Supreme Court said was that, well, the reason that you need a variance in the first place can't be the reason that this variance is denied. That circular logic. Well, you need a variance because it doesn't meet this criteria, and so we're not going to give you the variance because it doesn't meet this criteria. That will never work if you just say that the reason for denying it is the fact of why you need it in the first place. So if this discussion had resulted in some deliberation and findings, could have changed the outcome. As for whether a use is reasonable, if the use is allowed when it's an area variance, the area variance can't be denied simply because a ZBA disagrees with the use. And this concept really is an important one for ZBA decisions in general, and it kind of relates back to the recusal. ZBAs are applying criteria and concepts that exist statutorily and that have been interpreted by the courts over years and years. And to the extent any application meets all of the criteria, it's going to be difficult to uphold a denial if it's clear that all the criteria are met, and the denial ultimately, when you kind of weed through things, is just because one or more members or a majority of the ZBA members voting on it just simply didn't like the applicant or like the project or the type of use, etc. This point here, I think the final one really with regard to facts, meaning that if there's a factual issue that hasn't been addressed and there's nothing in the record on it, the court is often going to remand it so that the ZBA can weigh in first. So if you make all those decisions in the first instance, then maybe you only ever need the one appeal to get finality. One type of variance that does not need a showing of hardship is a physical disability variance. This is RSA 674-33-5, and this is a variance for a use to accommodate, basically like a reasonable accommodation for somebody who has a physical disability. And so because a finding of a hardship is not necessary, or not necessarily because, but the trade-off, perhaps because of that, is that this variance, if it is specifically explained as such, may be deemed to survive only so long as the particular person has a continuing need. This could be something like I think there was a case like this. I don't have it in my materials, but like a handicap ramp that, because it's a ramp and so it has to kind of switch back enough to get to the right elevation for a wheelchair to be able to actually use the ramp for access, bleeding into a setback, or for some other reason not being permitted under an ordinance, that ramp could be subject to a disability variance that may then no longer apply if the particular person having the need for it doesn't use it. So that is variances. It gives me a little bit of time for equitable waivers of dimensional requirement. This is almost kind of like a oopsie relief that can be granted. It's when a lot or other division of land is discovered to be in violation of a physical layout or dimension requirement. And you kind of forgive that, it really, in a practical sense. The property owner, again, has the burden of proof on the criteria, and it can be granted if and only if the board makes these findings. That the violation was not noticed or discovered until after substantial completion of the structure. So if you like, oh gosh, we're doing this wrong from the very first time a shovel hits the ground and you just keep doing it anyway, you're probably not going to meet that criteria. It was not an outcome of ignorance of the law or other just like bad faith ignoring it, right? If it's, you can't just be as totally asleep at the wheel. Equitable waivers of dimensional requirements also require that the physical dimension does not constitute a public or private nuisance, nor diminish the value of the property in the area. Obviously, you could always argue, I guess, if there's a setback, right? A butter could, that, well, even 1 inch into my setback decreases the value of my property. Obviously, that's a decision that could be weighed in on by experts, or that the ZBA could rely on its expertise. And certainly, there's generally some line somewhere that can be crossed for any of these types of decisions. But up and until you get to that line, there is a decent amount of gray area and discretion within the board. The last criteria is that due to the degree of past construction or investment made at this site where something is in violation, the facts, and I've put in italics here, constituting the violation so far outweighs any public benefit to be gained that it would be inequitable to require the violation to be corrected. And I apologize for the funky spacing on these slides. I'm not sure how that happened. The sort of safety valve is this RSA 674-30 and 33A, is that in lieu of the findings required by the board, you can find that the violation existed for 10 years or more and that no enforcement action, including a written notice of violation, had been commenced during that time. The waivers granted here are from physical layout, mathematical dimension requirements, not from use restrictions. So it's sizing and spacing, not you can have your water park here in this residential zone because of an equitable waiver of dimensional requirement. An equitable waiver is not construed as a non-conforming use. Now, good timing with the question that I just saw pop up. Substantial completion, Lane v. City of Dover. This case issued in April of 2025. I'm not honestly sure if it has been quote unquote published yet, meaning that it is binding. And if it's not published, it exists as persuasive value, meaning you can use it to support your decision, but that a subsequent case doesn't have to follow it. And so you see there, ready to be used for its intended purpose, or having largely but not all necessary components. So obviously that's helpful, but there are always still decisions to be made. The reality is when it comes to decisions issued by courts, they can continue to add criteria and add specificity to the thought process and to the elements and the criteria to determine something. But there's always going to be a job to be done by the ZBA to determine if it fits with in that criteria. So that case gives you the substantial completion. I'm looking at the time here, and I'm just going to kind of skip through, hit a couple quick hitters. One of the things a little bit different, although could end up being changed based on the statute. Don't know if there's case law specifically on it. The legislature more and more is wanting ZBAs and planning boards and all boards to more thoroughly document their findings with written findings. But at least as of this case, written findings on each element of an equitable waiver, not specifically required. And so 673-33A1D, this is an interesting and I think important distinction. It's supposed to be interpreted broadly so that if an applicant knows the facts and knows, hey, this is over a setback, but the town tells them that, well, the fact that it's over a setback doesn't constitute a violation. For whatever reason, they would be told that. So in that case, the applicant is ignorant. They're not ignorant of the facts. They know the facts, but the constituting the violation has been deemed to be important, such that you know the facts, but don't know the facts constitute a violation. You are then ignorant of the facts constituting a violation. The burden is on the applicant again to show all the elements. There are a few recent Supreme Court cases that came up since, I believe, last year's conference. Here's a case that supports what Cordell was telling you before. My Way Realty. It's a 2025 case where the ZBA cannot ignore uncontradicted expert testimony. And then the ZBA's refusal to allow applicant to present additional information after entering into deliberations was not unreasonable and was upheld. So I believe Cordell was saying that you could do that, but this case, though again, I'm not sure that it's fully published yet as in binding, have to follow with authority, but this case lets you know that, hey, if we've concluded the hearing and we're entering the deliberations and the applicant or an abutter or anybody just thought of some, oh my gosh, I forgot to tell you this really super important thing. Please, please, please let me tell you. You know, you got to use your judgment on what's fair and reasonable, but you were not obligated to do that. They had their chance. McGowan v. Town of Hampton is an interesting case because it deals with everybody's favorite topic, which is short-term rentals. In this case, somebody was using a loft as a short-term rental. I believe they got a violation notice. The homeowner said, wait a minute, we've been using this since before the short-term rental restrictions came into place, so it's a pre-existing use. And so what happened in this case is a kind of a combination of different types of analysis. The town, through its boards, wanted ultimately the decision to be that it was not a grandfathered use because it was not a lawful pre-existing use because it violated the ADU, accessory dwelling unit component of their ordinance. The loft did not have a cooking stove or a kitchen sink, meaning, according to the court's analysis, it did not meet the definition of an ADU, so it wasn't in violation of that statute. Since it wasn't in violation of that statute, it was a lawful pre-existing use, and therefore, though there is now restrictions on the STR use in this zone, they did not apply because their short-term rental use was indeed a lawful pre-existing non-conforming use. So they did not need a special exception in that case. It looks like it's 11:44, and so I suppose I can. 91A applies to ZBAs. Let me tell you that. That is important. And then I would just let you guys go on to the website to find that there is some recent legislation going on here. I had those sort of just in case for time purposes, but I am wrapping up now. If you're curious about that legislation, you can obviously look at the slides or go to Legiscan as well. And I think with that, I will conclude my presentation.
Okay, great. Thank you very much. This is very informative. That's a lot of information. So I appreciate all of that work that you did for it. And those people listening, you can always come back and check the recording if you need to get more of this information. So for now, that concludes this session, and we will now have a 1 hour lunch break.